We move on to section 55 of the Principal Act. Section 55 here said witness not to be disqualified by interest or being an executor. One of the requirements of the valid will is that it must be witnessed, or what we know commonly as attestation. So just a witness is not by, just because someone has an interest in your estate, they are not disqualified from being a witness to your will. By witness, what they want them to witness is you signing the will, not the content of the will, because also that would put you in danger. Imagine someone, your children witness to your will and see the content. What take you sooner than later, if, for example, you disinherited them or you gave, so here what it's reading is no person by reason of interest in or of his or her being an executor of a will is disqualified as a witness to prove the execution of the will. Execution is the signing of the will or to prove the validity or invalidity of the will. So we've amended the Principal Act by substituting for section 55 the following. Subsection 1, a person shall not by reason of interest in his or her being an executor or executrix, that's the first scenario, of a will be disqualified as a witness to prove the execution of a will or to prove the validity or invalidity of a will. Subsection 2, a person shall not apply. Subsection 1 shall not apply to a person who has participated in the writing or preparation of a will. So this protection is only for those who witness the signing, not for those who witness the writing. You have a page for attestation.
Yes, but when some things they are not don't know, they are not read.
They are there because they are valid wills currently, so we assume they are there. You're signing as a witness, so you're not signing something. You can say witnessed by. So you can sign as a witness, but not signing, just you don't know why you're signing. So you're informed that you're signing as a witness. So we move on to our clause 28. Clause 28 is a substitution of section 87 of the Principal Act. Section 87 reads, implied inclusion of illegitimate child and adopted children. At the beginning of this conversation, for those of us who are not here and have just joined us, we said the courts in a case, I think the case is Kajubi versus Kavari, declared that all children are children and there is no such thing as illegitimate child. So here a reference to illegitimate child is in contravention to that court case, because it reads implied inclusion of illegitimate and adopted children. So now we have amended this to read thus. Implied inclusion of children of a deceased, including adopted children, because especially in our African society, there is tendency to view adopted children as dependent relatives, not really as children. You don't look at them as, those were the deceased children. So those were children that you was helping, or those children that they got from. So they don't really value adopted children as they would biological children. So now I think that is what the law is trying to remedy and emphasize adopted children have equal rights as biological children, because you adopt, these are your children. Yes.
You know,
then you don't adopt
maybe adopted in one sense, because in African
we have greenery. After this, let's listen. The presented issues will arise.
Okay, just for purposes of clarity, adopted children here, we mean adoption legally by courts of law. You have gone through that process of adopting your child legally. Because otherwise in African culture there will be a thin divide between adopted children and dependent relatives. So they refer to those children who you went through the process of adoption in the courts of law. So in the amendment reads, in the absence of any intimation to the contrary in the will, child, son or daughter, or any word which expresses those relationships is to be understood as including any child whom the deceased parent has acknowledged as his or her child, either while he or she is living or in a will, or a declaration has been made, for example, a DNA, or a court declaration that that is your child, to the effect by a competent court. So all those are, this is merely to include all sorts of children. Yeah. Substitution of section 179 of the Principal Act. 179 refers to property transferable by gift in contemplation of death. A man may dispose by gift made in contemplation of death of any movable property which he could dispose of by will. So where you expect to die very soon, maybe you're suffering from a terminal illness, or say you're at war, you're an army man at war, you may, in contemplation of that death happening soon, gift your property to another in contemplation of that death. So you give that movable, and it's this property transferable in gift in contemplation of death is restricted only to movable property. Because I think it also serves the purpose of protecting you who, the potential deceased. Imagine you give out land and you don't die. Won't they finish you off before? So that's why I think it's restricted to movable property. And it reads, so now we have amended to read a person, not just a man, because it was reading a man may dispose by gift. So now we are saying a person, both man and woman. Yeah. Also, still you cannot gift, even if it's in contemplation of death, you cannot gift your matrimonial home. That is a principal residential holding or any other holding. That is protected under the law. So everywhere where there is reference to a man in this section, we've amended to read a person. So that is what has basically been changed here. Just the use of man has been substituted with the use of a person.